Hello, good afternoon, and welcome to today's event, Director's Duties in HealthTech. I'm Jen Esterby, I'm the HealthTech lead at Barclays Eagle Labs, and today we're delighted to be joined with Allen & Overy Law Firm, who are going to be talking about Director's Duties in the HealthTech sector. Catherine Gibault is a Senior Advisor, and Olivia Kendall-Martin, a Senior Consultant, who today will be providing a deep dive into key governance focus areas for rapidly scaling HealthTech businesses, covering the role of board and ExCo alongside practical tips for committee operations. But firstly, before I hand over to our speakers today, I wanted to give you an overview of Barclays Eagle Labs and how we're supporting the HealthTech sector. With a growing number of Eagle Labs across the UK, our focus is to help accelerate UK scale-ups, promote collaborative innovation across the entire ecosystem, and enable access to and training on new and emerging technologies. Since launching 5 years ago, we've grown our network to 26 sites across the UK, each one unique in its partnership and offering. And our collaborative spaces offer co-working, private offices, rapid prototyping facilities, and they enable startups to connect with like-minded businesses to help them innovate and grow. Our reach is far wider than our physical network, and around 2 years ago, we started looking at particular industry sectors that we felt were ripe for disruption, where there was a growing number of startups and also investment emerging. And we identified HealthTech as one of those sectors. We have a network of peers, mentors, partners, and experts who can help you achieve your business ambitions. And we've built up an ecosystem of over 360 HealthTech businesses in the last 2 years, with over 600 resident co-workers who've raised over £1 billion in funding. And we provide access to over 38 of our innovation partners who work alongside us within Eagle Labs. So if you'd like to find out more about Eagle Labs or the HealthTech programme in particular, you can get in touch with us via our website or email us directly. You can also subscribe to our newsletter via the website and follow our Twitter page to stay up to date with all things HealthTech. So finally for today, I just needed to make you aware of some following information. So we've asked Allen & Overy to join us today to provide some tips and tricks on director duties in HealthTech. The topics discussed are an overview of options for you to think about to help you with your independent research and business decisions. So they aren't intended as recommendations or advice. Remember as well as that, your business has its own individual circumstances, so the statement and views expressed today may not be applicable or suitable for your business. So without further ado, let's begin this event, and please allow me to introduce you to our first speaker, Catherine.
Hello, and welcome to this A&O training session on directors' duties and governance for HealthTechs. First, some introductions. I am Catherine Gibault, Senior Advisor at A&O Consulting, where I advise the management team and lead on our external training strategy. Before joining A&O, I practiced as a barrister in QC for over 20 years at the commercial bar, and I have first-hand experience of the litigation that can result when directors don't comply with their duties under the Companies Act, or when companies don't understand the importance of good governance, culture, and compliance. The consequences in terms of penalties, costs, management time, and the company's reputation can be very serious. Presenting with me today are Emma Cody and Olivia Kendall-Martin. Emma is one of our leading equity capital markets lawyers and is a senior associate within A&O's London corporate practice. Emma advises on corporate governance and transactions, including IPOs, equity investments, joint ventures, and transactions involving high-growth companies, and is an expert in directors' duties. Olivia is a former regulator at the FCA and now a senior consultant within the A&O Consulting team in London. Olivia leads our strategy for startups and rapidly scaling firms, which allows those companies to access advice on governance, risk management, culture, and compliance. In terms of scale-ups, A&O Consulting have a particular focus on helping scale-ups to gain access to high-quality advice, which is proportionate to their needs and their stage of growth. We, in fact, offer scaling-up firms free access to our know-how site, which contains practical self-help tools and resources on topics such as business model and strategy, governance, risk management, and compliance. To access this know-how site, there is an email address included at the end of this webinar. As experts in these important legal and governance issues, Barclays Eagle Lab have invited us to put together some training to assist HealthTechs navigate some of the issues arising out of directors' duties and governance on the boards of your companies. This is the first of our training sessions. Emma will start by outlining what directors' duties under the Companies Act 2006 actually involve in practice for your companies. We will then consider a scenario that raises some of the conflicts issues that can arise for directors in the health tech context. I will then delve into what good governance means in practice and the role of the board, and Olivia will round off this training session by considering the key roles of chair of the board, CEO, and non-executive directors, and outlining what is best practice in relation to the conduct of your ExCo meeting. I shall now hand over to Emma on directors' duties.
Thanks very much, Catherine. Hi, everybody. Well, we have a lot to cover, so I suggest we get straight into it and maybe perhaps start first with explaining where all of these directors' duties come from. As you can see on the slide, these are the duties and they can be found in the UK's Companies Act 2006. This legislation sets out the general duties of directors of companies in England and in Wales. And these are effectively the core duties owed by a director to her company. But they're not an exhaustive list, and directors must also comply with certain duties which exist not in the statute, but in what we call common law. And unfortunately, not everything there is for a director to remember is on this slide, because there is a host of other legislation governing the duties of companies in relation to various other matters, such as environmental issues, employment, health and safety in work, and so on. So a director should really ensure that her company complies with these laws, but these legislative requirements are probably beyond the scope of what we're going to talk about today. So before we get into each of these codified duties in a bit more detail, we should probably remind ourselves of why all of these duties are important. And as Catherine has mentioned, that is because a breach of a director's duties can lead to personal liability, either in the form of civil liability to the company or to other persons, for example, the shareholders of the company, or perhaps even more worryingly, it can lead to criminal liability as well. And if that's not enough, failure to fulfill your duties properly can also lead to disqualification from being a director in the future. So this is all really key, important information to bear in mind. So maybe perhaps we start by looking at the first duty, which is the duty to promote the success of the company. So this duty states that a director must act in the way he or she considers, acting in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole. And when deciding what success is, a director must have regard to a non-exhaustive list of 6 factors, and those are the ones that you can see on the screen. So that list covers the likely consequences of any decision in the long term, the interests of the company's employees, the need to foster the company's business relationships with its suppliers, its customers, and other stakeholders, the impact of the company's operations on the community and the environment around it, the desirability of the company maintaining a reputation for high standards of business conduct, and finally, the need to act fairly as between all of the members of the company. So, when making a decision, a director should give proper consideration to each of these factors. Now, what do we mean by success? Well, it's really for the directors to make a good faith judgment about what success means for the shareholders as a whole. But generally speaking, success is essentially what the shareholders want the company to achieve. And for commercial companies, unsurprisingly, it'll generally mean a long-term increase in the value of the business. Now, there's an important point here about record keeping, and when making business decisions, having regard to the list of factors I've just mentioned, directors should not simply be going through a box-ticking exercise. There's nothing to be gained by creating a paper trail, simply stating that the directors have considered the list of the 6 factors we've talked about. They need to explain in a bit of detail how you have arrived at that decision. It's also really important to remember that evidencing a consideration of the factors, for example in your board minutes, can be a very useful tool when the directors anticipate a problem, or if they want to have on record a demonstration that they've carried out their duties properly and have considered each of these duties carefully. A director is not entitled to take into account the interests of only one shareholder in priority over the shareholders taken as a whole. And as you can imagine, this can often present a problem for a director who has been appointed to the board by a particular shareholder or group of shareholders. For example, where the company is a joint venture company or has a significant shareholder. And this is because that director is not allowed to exclusively take account the interests of that shareholder who appointed him. In addition, a director has to act in good faith and put the interests of the company and its shareholders ahead of any interest he or she may have in a personal capacity. So, for example, directors may well have other interests or loyalties to another group company, to a shareholder which has nominated him or her as a director, or to an unrelated company or their own business. None of those interests will diminish the duty of the director to act in the best interest of the company. A director may make a decision for the company that benefits both the company and the other interest he or she may have, provided that the other interests are not placed ahead of the company's. Now, what if the company is insolvent or nearing insolvency? Well, in that case, the interests of the creditors will prevail over those of the shareholders. And this clearly represents a shift in the duty and is a very important one to remember. Moving on to the duty to exercise independent judgment. What do we mean by this? Well, a director is able to take advice. That advice must not be followed blindly. He should exercise his own judgment when considering the advice and ask appropriate questions. Similarly, a director of a subsidiary company can't simply follow group policy or directions blindly. It all sounds well in theory, but this can sometimes prove difficult in practice for a director of a subsidiary company. Because as well as exercising his independent judgment, he must also promote the success of his own company within the group, subject to any provisions that may be in the articles, as we've mentioned above, allowing him to take into account the interest of other group members. A similar issue frequently arises in relation to nominee directors. So even if the articles seem to allow a director to follow the instructions of his appointer without being in breach of the duty to exercise independent judgment, the director will still need to reconcile this with his other duties, such as the one we've just spoken about, the duty to promote the success of the company. Now, will a court question the board's judgment? No, generally they tend to avoid doing this, but nevertheless, boards must exercise due care, skill and diligence, which leads us nicely on to the next duty. And that's the duty that a director must exercise reasonable care, skill and diligence. This is defined as being the care, skill and diligence that would be exercised by a reasonably diligent person with the general knowledge, skill and experience that may reasonably be expected of a person carrying out the functions carried out by the director in relation to the company, and the general knowledge, skill and experience that that director himself has. What this effectively means is that a person shouldn't take on a directorship unless they are sufficiently qualified or experienced to be able to fulfill the functions that they might reasonably be expected to carry out. And in some ways, it may sound unfortunate that if you are particularly talented, if you are a person with particular skills and qualities, you'll be held to a higher standard than someone who does not have those qualities. And you will have to meet that higher bar that you have set for yourself in carrying out your duties. Two questions which A&O often receives in relation to directors' duties relates to the functions that directors are expected to fulfill. Directors often ask, how much do I need to know about the company's day-to-day business? And how far can I delegate functions and rely upon others to do some work? Well, the principles established by case law are that each individual director needs to inform himself about the company's affairs and join with his co-directors in supervising and controlling them. A board is, of course, able to delegate specific tasks and functions and to trust the competence and integrity of their management to a reasonable extent. However, overall responsibility is not delegable, and a director may need to take care to ensure that delegation has been made to an appropriate person and that those persons are discharging their functions properly, and that there is an adequate system of controls and supervision in place to monitor this. Now, can a director be liable for an error in judgment? Well, no, so long as account has been taken of all the relevant factors and the decision is not objectively unreasonable. So to be liable for a decision which turns out, with the benefit of hindsight, to have been a bad one, a director must have taken a decision that no reasonable director would have taken. If a director takes into account all relevant factors, has regard to his duties, and reaches a decision which turns out to be unfortunate, she should not be liable, and courts do not generally try to second guess board decisions. Over the years, there's been an increasing emphasis placed on the role of non-executive directors. And questions often arise about the position of NEDs and the extent to which they may be liable for failures within a company. This really depends on the circumstances, including the part which the non-executive directors could be reasonably expected to play in the management of that company. So, if a NED suspects that the management of a company is not performing their functions properly, the role can become more onerous. And the published guidance on board effectiveness states that NEDs should have access to independent professional advice at the company's expense where they consider it necessary to discharge their duties. And directors, in particular non-executive directors, should not be afraid to speak up when they have concerns about the management of a business. Now we'll look at directors' conflicts. And maybe just talking about the basics to begin with. The Companies Act states that a director of a company must avoid a situation in which he or she has or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. Now, we call this type of conflict a situational conflict. The duty to avoid situational conflicts is very broad and it catches potential conflicts as well as actual conflicts. There is, however, a materiality test, and the duty won't be breached if the situation can't reasonably be regarded as likely to give rise to a conflict of interest. In addition, the duty won't be infringed if the matter has been authorised, and we'll talk about that in just a moment. But for now, maybe we consider, well, what is an interest? Well, the term interest is not defined, but essentially an interest should be considered to be a very broad term, including anything or any connection which could potentially divert the director's mind from giving sole consideration to promoting the success of the company. So, what indirect interest may be caught? Well, the reference to indirect interest probably means the interests of persons who are connected with the director, and those interests should be considered when deciding whether or not a director has a conflict. So, can we think of potential examples of conflict situations? Well, these could include directorship of more than one company, where the interests of the companies conflict, or possibly may, subject to the materiality test, conflict. Competing with the company, either directly or indirectly. So, for example, having an interest in a company or a business which does compete with the company in question. Or potentially, maybe you might be a potential customer or a supplier of the company. Or you might have an advisory relationship with the company, for example, as a legal or financial advisor of the company, or indeed a competitor of the company. You may be connected with a substantial shareholder of the company, and that might rise quite frequently in the context of joint venture situations. And of course, as we've mentioned, an indirect interest in any of these examples, for example, through a close family member, would also be considered a potential conflict. So this list is, of course, non-exhaustive, and it just is really illustrating certain situations which may constitute a conflict situation. So we mustn't forget that whether or not a conflict situation actually exists will depend very much upon the relevant facts. There is also a duty to declare an interest in transactions and arrangements. If a director has an interest in a proposed or an existing transaction or arrangement with the company, this is called a transactional conflict, and he must declare it under Section 177 of the Companies Act. If a director of a company is in any way directly or indirectly interested in a proposed transaction or arrangement with the company, he must declare the nature of that arrangement and the extent of the interest to his other directors. What interests or transactions or arrangements need to be declared? Well, there are a number of elements to this question. The first is looking at what is an interest. As we've seen with situational conflicts, an interest is not defined, but case law tells us that any transaction in respect of which a director has a connection which will or could potentially divert his mind from giving sole consideration to the best interests of the company should really be considered as a transaction in which he has an interest. As in relation to situational conflicts, the reference to indirect interest here may mean that interests of persons connected with the director should also be considered when deciding whether or not a conflict exists. Well, what happens if a director isn't aware of that interest? Although no declaration obviously is required where a director isn't aware of an interest he may have, a director will be treated as being aware of matters which you ought reasonably be aware of. So from a practical point of view, this effectively means that directors should undertake a reasonable amount of due diligence regarding their potential interest in order to avoid potentially breaching the duty inadvertently. The director concerned will need to declare his interest in the proposed transaction or arrangement unless an exemption applies. And failure to declare an interest may result in a contract with the company being declared voidable, or, more worryingly, it can also potentially be a criminal offence. Finally, there is a duty not to accept benefit from third parties. A director must not accept a benefit from a third party conferred by reason of his being a director or his doing or not doing anything as a director. So if accepting the benefit can't reasonably be regarded as likely to give rise to a conflict of interest, the duty, of course, won't be breached. However, there is no scope for authorisation by independent directors. So in the case of any doubt, a benefit would need to seek shareholder authorisation before receiving that benefit. Now, this issue frequently crops up in respect of corporate hospitality and gifts. And for that reason, many companies have policies concerned with anti-bribery legislation, as well as directors' duties, that give directors specific guidance as to what is and what is not acceptable in this area relating to corporate benefits. So these are the conflict issues. How can these be authorised? So if we have a transactional conflict, a director is required to declare the nature and the extent of the conflict before the company enters into the transactional arrangement. And they can do that either at a board meeting, by notice in writing to other directors, or by way of general notice, to the effect that the director is to be regarded as interested in any transactional arrangement with that particular entity. And they are required, of course, to update the declaration if it becomes inaccurate or incomplete in any way. Looking at the middle of the screen then to situational conflicts, well, those can be authorised either by the non-conflicted directors or indeed by the shareholders themselves. Also, in certain very specific categories of circumstances, it may be possible and indeed appropriate for particular situational conflicts to be authorised in the company's articles of association. And this frequently arises in the context of joint venture transactions, which we often see in HealthTech companies. A typical joint venture arrangement will allow each party to nominate a certain number of directors to the board of the company. And the fact that that director is appointed by one of the joint venture company's shareholders is likely, of course, to place him in a position of conflict between his loyalty to his appointing shareholder on the one hand and his duties to the joint venture company. So any such conflict will, unless authorised, cause the director to breach his duties. And so the articles frequently provide for this inherent conflict to be authorised through the Articles of Association. And then finally, looking at third-party benefits, the key question here is whether the acceptance of the benefit can reasonably be regarded as likely to give rise to a conflict. And as we've mentioned before, there's no scope for authorisation by independent directors. In the case of doubt, therefore, a director does need to seek shareholder authorisation. Moving on to the duty to act within powers. So here, a director must act in accordance with the company's constitution. And for this purpose, the constitution includes not only the company's articles of association, but also decisions taken in accordance with the articles and other decisions that might have been taken by the members, or indeed a class of them, if those can be regarded as decisions of the company. So most companies these days have unrestricted objects. However, if for any reason a company's constitution does impose limitations on the company's activities or upon the authority of the directors must comply with those limitations. In addition, a director must only exercise his powers for the purposes for which they are conferred. So examples of improper purposes would include acting to protect a director's own personal position, to make matters perhaps difficult for a particular shareholder, or to try to influence the outcome of a shareholder vote, or indeed doing something like issuing shares to thwart a transaction or to potentially assist a takeover bid. And finally, let's take a quick look at duties of confidentiality and disclosure. A director owes a common law duty of confidentiality to his company. Clearly, this duty overlaps with duties to promote the success of the company and the duties we've just mentioned to avoid conflicts. And as we will see shortly, it can be particularly relevant in the context of multiple directorships and in joint venture situations. The duty of confidentiality means that even when a director is appointed by a shareholder, she must not, without the authority of the company, disclose to that shareholder any confidential information relating to the company which has been gained by her as a director of that company. In addition, the presence on the board of a competitor's representative may in practice really inhibit the willingness of the other directors to make full disclosure to the board. So where such information would be of value to a competitor, directors may find themselves faced with the conflicting duties of providing the board with their detailed information, but also acting in a way most likely to promote the success of the company. So in certain circumstances, mere notification that a subject is to be discussed may itself be potentially damaging if that fact is known to a competitor. For that reason, issues relating to such kinds of interested directors on the board may be specifically addressed by the company's Articles of Association by providing that an interested director or a director of a competitor on the board may not receive certain papers or may not be allowed to vote on certain issues or may be required indeed to withdraw from certain meetings and to not pass on that information to shareholders. And in this way, the potential issues relating to confidentiality can be managed. Now we're going to move on to an example to see how all of these directors' duties are applied in a real life scenario. So let me hand over to Catherine to maybe set the scene for the scenario.
Thank you, Emma. So as Emma says, we will now consider a scenario where some of the conflicts issues that she's recently outlined arise in practice. Let us assume you're an executive director on the board of a UK company. The company specialises in carrying out research for pharma companies using NHS patient data. You have executive directors and non-executive directors on your board of your company. And one of the NEDs on the board also has a separate role carrying out academic research at a non-profit research institute. Now, that institute has no connection with the company other than that it is health-related research. During their time working at the institute, the NED conducts some potentially groundbreaking research using the institute's resources. The NED realises this research could be beneficial for the business of the UK company, tells you about this research, and says he intends to tell the board at the next full meeting. What should you do? Well, we have seen from Emma's presentation on the Companies Act duties that a director of a company must avoid a situation in which he has or can have a direct or indirect interest that conflicts or may conflict with the interests of the company. And this applies in particular to the exploitation of any property, information, or opportunity. So first, there are many questions you would need to ask before you could really even start to understand the potential range of conflicts here. For example, who funds the institute? Is it affiliated to an academic institution, a healthcare provider, a government, NGO? What is the purpose of the institute and what does its policy and government documents state? Is there a code of conduct applicable to the institute? And what does it state about this type of situation, if there is one? Is the NED employed by the institute, and what are the terms of any contract or consultancy between the NED and the institute? If the NED is not paid for their work at the institute, does this make any difference? The terms of engagement between the institute and the NED may differ if there is no remuneration, but you would still need to establish what those terms are, and whether or not the NED is entitled to share this information outside of the institute without breaching those terms of engagement. Does the Research Institute own the rights to the NED's research? It is likely that the institute will have policies or even contracts that govern this issue. And so you need to ensure that you find out what the legal situation is as soon as possible. Does the NED stand to gain financially by exploiting the research breakthrough? Is this exploitation going to breach any duties he owes to the Institute in any capacity? And what confidentiality rules apply to the NED at the Institute? It may be that the NED is in breach of one of these policies, even by having mentioned the groundbreaking research to you, as you are a director of a different health research company.
Thank you, Catherine. And so then, considering the position from your company's perspective, you might ask yourself the following questions. Is the NED in breach of his duties to the Institute by having told you this information? If so, this places you in an exposed position as the recipient of confidential information, and you should certainly ensure that the information goes no further, whilst considering also how to protect your own position. What company policies, codes of conduct govern this situation and your duties in this situation? Your company will have a conflicts of interest policy and a policy dealing with confidential information. You need to consider these and to follow those policies where appropriate and applicable. Finally, what expectations do you have for your NED in this situation? He needs to understand the potential for conflicts of interest and take immediate steps to manage any conflicts between his role on the board and your role at the Institute, and his role at the Institute, sorry.
Yes, that's right. And in your role as an executive, you should be advising the NED that there may be a conflict, whether it's actual or perceived. And as we mentioned before, he should be getting some independent legal advice about his position. If he's able to do so without breaching his confidentiality obligations, the NED has a responsibility in this scenario to make sure your board is aware of his conflict and is taking steps to address it, either by disclosure or by another strategy. And as we know, every board member has a duty to avoid or manage these conflicts of interest. So if he or she has not already done so, the NED should inform the chair of the board. And in larger companies, it would also be advisable that the relevant control function is informed as early as possible, as soon as the conflict is identified. So typically that would be informing the company secretary. The Research Institute itself should also be informed immediately as to the conflict. And that's because the Institute may want to take action to restrict access to information or to specific projects for that particular NED. And if full disclosure is given to both your board and the Institute authorises the NED to explore the commercial exploitation of the research by the company, with the benefit of independent legal advice on both sides of the transaction, this could actually result in a joint venture which benefits both entities. The Institute would be able to set out in contractual terms how it's willing for the exploitation to take place, the legal terms of that, and this would allow for the board to consider this as a commercial opportunity and to consider whether or not those terms are acceptable. The NED should really assess whether or not they're able to exercise independent judgment in their role as a NED while still carrying out research and having access to sensitive information within another health research organisation. Ultimately, however, depending on the Institute's reaction to full disclosure, your NED may need to consider stepping down from one of her positions. So hopefully that scenario provides a little bit of helpful context to the theory on how conflicts are managed in practice. And now I'll hand back over to Catherine to take us through some governance issues in relation to HealthTechs.
Thank you, Emma. I'm going to consider now some issues relating to governance in practice. And particularly in relation to HealthTechs. So setting the scene for the health tech industry in the UK currently, there are approximately 4,000 companies operating in health tech in the UK. That leads to a £24 billion industry turnover. In terms of digital health investment, the sector is on track for 2020 to be the largest funding year to date. It is on track for the health tech sector, in fact, to reach $12 billion in funding by the end of this year, according to Rock Health's latest digital health funding report. As a starting point, what do we actually mean by governance here? In a nutshell, governance means the system by which the company is set up, directed, and controlled. The board of directors is responsible for the governance of their company. Governance is not just about organograms and the design of committees, subcommittees, and reporting lines. It is about the effectiveness of those systems in practice. It is about the way that day-to-day operations work or do not work. It is about being clear about who is responsible for what, so the delegation lines and the lines of escalation. It is about the ExCo as well as the board of directors. So why is good governance important for a company? It, first of all, significantly affects the way that a company behaves towards its customers and stakeholders. Secondly, governance affects the way it operates in the markets relevant to the company. And thirdly, it is a prerequisite for a well-run company. In the context of health tech companies, good governance is of vital importance, particularly because of two factors. Firstly, the highly regulated nature of the industry. Regulators that may be looking at governance issues include the CQC, the Information Commissioner's Office, the Health Research Authority of the NHS, and the MHRA. And the second issue is the need for very significant sums, investment sums, to fund the research and production and to scale the companies. Serious financial backers will not invest in health tech companies that cannot evidence good governance and having their proverbial ducks in a row. So let's move on to the next slide and consider some of the proven benefits of good governance. First of all, informed decision-making. The right people all the way up the organisation, all the way up to board level, have the appropriate, accurate information to enable them to make the decisions they need to make. This means in turn that the board will have the appropriate and timely information to ensure better strategic planning for the company. And this is particularly important when the company has a high growth strategy and is embracing rapid change. Good governance, in turn, encourages positive conduct in the organisation because members of the organisation are held accountable for their decisions and their behaviour. And flows of information and KPIs are designed so that poor conduct is not easy to hide. This, in turn, encourages good behaviour and creates a disincentive to poor conduct, which builds a strong culture in the organisation. Internal controls are strong when there's good governance. Risk and controls functions are respected. There is transparency through careful communication and information flows. So you cannot get away with poor conduct or fudging KPIs. And in turn, this type of strong governance and positive culture attracts talent, securing the future of the company and maintaining investor confidence. So that ensures that funding rounds are successful and the company is able to deliver the purpose on its purpose to its stakeholders. So what is the role of the board if we move on to slide 20? Key considerations we've listed down the left-hand side of the slide, and I want to highlight 4 points in particular here, 4 of the key considerations. The first being the purpose and strategy. Now, the board is responsible for defining the company's purpose and agreeing strategy for the company, bearing in mind both the shorter-term goals of the company and also longer-term sustainable success, so that the goal is delivering value to all stakeholders in the long term. And secondly, the culture within the company. The board takes the culture of the company very seriously, or it should, because this is what shapes the day-to-day experience of the employees of the firm. It is hard to measure, but critical to get right. It takes the tone from the leaders of the firm, and the culture is shaped by the values of the company that have been agreed by the board, and in turn, the conduct of the members of the company is shaped by its culture. So the board must try and assess and monitor the culture of its firm. This is particularly important in a highly regulated industry such as health tech, where conflicts are very frequent, as we've seen, and the success of a company often depends on huge rounds of funding. There should be zero tolerance to misconduct and zero tolerance to failures to manage conflicts of interest. Picking up on governance and controls as another key consideration, the board is responsible for putting in place robust governance arrangements, which include a clear organisational structure, well-defined, transparent and consistent lines of responsibility, and adequate internal control mechanisms such as administrative, risk management, accounting and audit procedures. Also, appropriate systems of delegation from board to management, down the organisation, as well as escalation up the organisation from business lines to higher management and up to the board where necessary. And finally, on this slide, I want to highlight that the board must set the company's risk appetite and its overall approach to risk management. It must, in effect, ask itself, what is the extent of the risks that the board is willing to take to implement the strategy agreed? Then, the board must effectively conduct a robust assessment of the company's principal risks and those risks emerging to ensure that effective procedures are in place to identify, manage, monitor and report any risks and changes to risks over time. And moving on to the next slide, we consider what makes an effective board. The first point on the left-hand side, clear leadership and purpose. In our experience, the chair of the board is critical to achieving this. The chair must set out a clear purpose and strong leadership. And the chair and the members of the board must be seen to be role modelling behaviours that are in line with the company's values, that align to the company's purpose, strategy and priorities. Leaders cannot tell employees to do one thing, but themselves do the opposite. Secondly, high quality decision making is critical to an effective board. And we've touched on this already, the importance for good information to be shared throughout the organisation. One of the hallmarks of good governance is that the right people all the way up the organisation, including to the board level, have the appropriate, accurate information they need to make the decisions. So if this is achieved, then the board should have the high quality MI it needs for good decision making in practice. In addition, the chair should ensure that meetings are sufficiently regular, there are not lengthy gaps or periods between the board meetings, and that there's no single dominant voice on the board. All voices should be encouraged and heard at board meetings. A third feature of effective boards is that there are open channels of communication, both vertically and horizontally, so that first, boards are able to listen to various stakeholders in the company, including employees, customers, and funders. And secondly, that there is effective and open communication between the board and management, so your horizontal communication. And finally, boards are most effective when they have a balanced composition of members. A balanced board will have been carefully put together to comprise the right mix of skills, experience, and independence, to consist of a manageable number of execs and non-execs, so there is time for all to contribute at a meeting, to create cognitive diversity, which is so important, so that different board members' backgrounds and experiences allow them to approach difficult problems from different and diverse perspectives, and groupthink can therefore be avoided. And finally, to ensure that each board member has sufficient time to devote to the role. And then moving on to challenges facing the board, we've highlighted 4 particular challenges here. The first is the conflict between the short-term pressures from investors and long-term considerations. This is not a challenge particular to health tech companies, but to all companies who have investors and funders. And the board must try and avoid the risk of short-termism and focus on sustainable growth. Secondly, independent directors of the board should get to know and understand the company and its culture and its norms, but also maintain a sufficient distance to be able to offer an objective viewpoint to management and enable that challenge that the board is there to do. INEDs must be constructive when working with executives and management and not get too close to management so as to lose their independence. The third challenge we highlight is that of the group dynamics of the board. And in my experience, this is the most important challenge to get right for the effective functioning of the board. It's probably also the most difficult to get right in practice. A huge amount depends on the personality of the chair and the personalities of the board members. But harnessing the energy, knowledge, and experience of these often hugely impressive board members is a skill of the most effective board chairs. And finally, the board must navigate a path focusing on the commercial needs of the company, while still taking account of the sometimes conflicting voices of various stakeholders, including often employees and contractors, patients, customers, NHS trusts, regulators, funders, and the wider community. This is no mean feat, and when companies get this wrong, we see more and more the impact of social media in publicising this, causing reputational damage to companies in a matter of seconds. At the helm navigating these challenges for the board are the chair and the CEO, and Olivia will now lead in exploring these roles and their importance for the good governance of the company.
Thank you, Catherine. So I'll now take you through the roles and responsibilities of the CEO and the chair, and some of the best practice focus areas for these individuals within scaling up firms. So often these roles within a startup can become blurred, but it's essential that they are sufficiently separated and the roles and responsibilities of each are clearly understood by both the individuals, the executives, and the members of the board. An effective working relationship between the two can help the company ensure full alignment between the board and the ExCo, which ultimately helps drive success in the long run. So the CEO is the most senior executive within the company and reports to the board. This role within the company is critical and comes with it a variety of responsibilities, in particular the overall performance of the company and developing and delivering the agreed business strategy as approved by the board. Equally important is the CEO's focus on the company culture. In this role, the CEO is a linchpin for setting the tone from the top and must be seen to embody the cultural values of the company in day-to-day interactions, setting the standards of what is expected to both senior management and employees. This is a key focus area for regulators of financial services firms, but it's also an area of paramount importance for HealthTechs, as public scrutiny continues around the ethics of companies handling personal data and medical records for commercial use. So as a company grows and reaches greater scale to become more established, the CEO will need to focus on the skill sets of his or her senior management team to ensure that they have the capabilities and the support they need to deliver the strategy. This might include in the long run making new hires or arranging training for individuals to ensure that the team has the collective ability to make the strategy a success. The CEO also has a very important role to play in acting as the key link between the board and the executive. This includes ensuring that the board understands the view of the senior management team and have enough visibility of the company, its operations and direction of travel at all times, bringing issues for discussion and approval at the right time, and cascading board decisions and requests to the management team. The chair, on the other hand, is the most senior board member and plays a pivotal role in ensuring the day-to-day effectiveness of the board, to ensure that it works as a team and maintains focus on key issues facing the company to effectively deliver against all aspects of its mandate. This is critical to help mitigate the challenges boards often face, as highlighted by Catherine in previous slides, around leadership and purpose, high-quality decision-making, and retaining open channels of communication between stakeholders and the executive. The chair also has a role to ensure appropriate boardroom culture, starting from ensuring that enough time is allocated to matters of discussion, decisions are reached using the relevant information required, and that board members are heard to encourage and facilitate the provision of a variety of opinions and perspectives. Beyond this, the chair has a responsibility to ensure that the composition of the board is appropriate for the company, both in the present and for the future company strategy. This means ensuring that members are well equipped to have sufficient knowledge and capabilities to be able to provide enough debate and challenge to the decisions of the executive, especially if the business, for example, wants to pursue the use of new technologies or enter into a new market. The chair plays a very important role in making sure that there is effective communication between investors and the company, ensuring that their views are conveyed to the board and reflected within discussions and decisions made. This also means that the chair must be someone who can command the respect of relevant stakeholders in order to facilitate this information flow, and to gain their trust in guaranteeing that their voices will be heard. Finally, and crucially, the chair provides ongoing support and advice to the company CEO on strategic and advisory matters. It is essential that this relationship works well and that interactions happen on a regular basis, including outside of board meetings. We've seen a situation recently where a restructuring of the ExCo occurred upon instruction from the CEO, and where the board weren't informed. One of the NEDs found out independently, causing great embarrassment for the rest of the board. So having a mechanism in place to ensure information flow between board meetings is therefore essential, and a problem that can be easily solved with good communication between the CEO and the chair. So now moving on to the role of the non-executive directors, the NEDs. These individuals sit on the company board and provide independent oversight and constructive challenge to the executive. Although both the executive and non-executive directors are treated as directors under the Companies Act, there is a difference in their day-to-day role, which should be made clear in their job descriptions. NEDs should bring an independent judgment to bear on issues of strategy, performance, and resources, including key appointments and standards of conduct. Their role in bringing an independent and objective perspective to board discussions and decisions is therefore crucial. Often, NEDs are appointed for their diverse backgrounds, their particular professional experience or expertise, or even personal qualities, in order to bring this perspective and to help play a valuable role in monitoring the company management. It's common practice for NEDs to hold more than one NED position on other company boards within the same industry. As we have discussed in the conflict scenario earlier in this session, it is important that companies are able to spot where these conflicts of interest may arise and have appropriate methods in place to manage these conflicts. Sitting on multiple boards can also bring with it time capacity issues. This is something that you would want to discuss with your NED up front to have the comfort that they'd be able to invest enough time in the company to gain a comprehensive understanding of the business. We have recently seen a situation where this was an issue within the sector, resulting in overstretched workloads for the NEDs and ineffective challenge at the board. It is also important for NEDs to ensure that they have some kind of interaction with employees outside of the board, especially given their responsibilities in respect to the workforce and to help the board drive and assess the culture agenda. One good way that NEDs can do this is to establish skip-level meetings with employees throughout the year. So, for example, informal meetings with employees 1 or 2 levels below the executive to get a sense of how these employees are feeling and a picture of the culture at a working level. So now that we've discussed the role of the NEDs and the board and the key individual responsibilities to ensure its effectiveness, I'll now talk a little bit about the executive committee. So the ExCo is a committee of the most senior management within a company, chaired by the CEO. It is usually a forum in which key decisions regarding the day-to-day operations of the business are made. It is typically responsible for organizational oversight with a wide variety of responsibilities, such as monitoring the progress of the strategy and performance against it, business planning and resourcing, ensuring adequate discussion and management of key risks, including those to the business model, strategy, stakeholders, clients, and employees. And it also has responsibilities for the culture of the company and remuneration of its management and its employees. It is typically more agile than the board, meeting more frequently from once a week to once a month, depending on the business size, and can discuss and make decisions on a wide variety of matters, as determined by the committee terms of reference and agreed by the board. It can also be a forum in which senior managers can hold each other to account for their own actions and decisions made within the business lines. The ExCo membership is usually composed of heads of business lines and those crucial to the management of the company. Within a HealthTech, this may include the CEO, the head of product development, head of sales, and your chief information officer. Depending on your size, this could also include your chief risk officer or your chief finance officer. Importantly, the ExCo has a responsibility to report its own decisions and views back to the board on a regular basis, so for example once a month, to ensure that the board is able to discharge its responsibilities in maintaining oversight of the company performance sufficiently. So the following slides after this contain general best practice guidance for management committees to follow in terms of reporting and day-to-day meeting effectiveness. So moving on to management information. Having fit-for-purpose management information is absolutely key to effective decision-making, be it at the ExCo or the board. Without good management information, it's hard for senior management to measure business performance or to take any effective decisions, ultimately leading to poor outcomes. We have outlined here 3 essential components of what we would define as good MI. So first, it should be timely and relevant. There's no point in the ExCo or the board receiving data which is, for example, 6 months out of date. Secondly, it should be clear, concise, and audience appropriate. The key here is not to overburden the ExCo and the board with the MI. It's about telling the story that the MI is producing. So, for example, highlighting trends, finding outliers for discussion, and mapping these back to business performance indicators to find out what it really means for the business. And finally, it should be accurate, with any assumptions clearly stated for user understanding. Boards and ExCos should receive relevant MI in advance of committee meetings, alongside all other items for discussion and decision. Members of these committees should ensure that these form the basis of their decision making, and that where there are outliers, that these should be investigated. So moving on to effective meeting management, we've included a slide here on our top tips for effective meeting management, some of which may seem obvious, but you'd be surprised how many companies get these things wrong. So getting these arrangements right can be regarded as a really good indicator of good governance. I'll just highlight a few. So good practices to highlight could be something such as scheduling regular meetings and creating agendas. So ensuring that the ExCo and the board have sight of upcoming items for discussion, and importantly that they have time to read through papers before they convene the meeting. On this point, we would advise that papers are kept short so that the relevant committee members are able to digest the information given to them. In addition, these forums should not be used as a show and tell exercise. Too often we see committees taking up valuable time talking through materials which committee members should have already seen in advance. This time should be conserved for items for discussion where appropriate and items for decision only. And then in terms of taking minutes of each meeting, this is also essential for proper record keeping and may help clarify actions arising and the individuals responsible. These should be circulated post the meeting to all those in attendance and should form the basis of an action log which can then be tracked. I'll now hand back over to Catherine to wrap up the session, but I hope that was useful.
Thank you. So that concludes this session of training on directors' duties and governance in practice. We hope you found it useful. Thank you, Emma and Olivia, for co-presenting with me. And we look forward to delivering our next session of training on how to build a team in health tech companies.
Thank you so much, Catherine and team, for delivering such an insightful session today. If you have any questions, either for Barclays or Allen & Overy, please get in touch directly with us. And if you'd like to attend the next session that Catherine mentioned, which is all around building a team in health tech, please visit our event page on our website, labs.uk.barclays, to register for your attendance. Thank you.